Good morning, everyone. This is Andy Bobrack. I'll introduce you to Tyler in a little bit here, but I'm going to handle just the introduction and preliminary section of our presentation. It's great to have you with us on this day. We were pleased to have such a strong and positive response for the webinar. Just by way of introduction, for those of you who may know, and I know we have a number of clients and other friends with us today, it's great to have you. But Bond is a full-service commercial firm with over 230 attorneys. We've got offices across New York State, including in New York City and Long Island, as well as in Kansas and Florida. Our firm is unique in the sense that we have a very large practice consisting of over 70 employees who are solely dedicated to representing employers and management in the labor employment realm, including matters concerning the NLRA and the National Labor Relations Board, which is, of course, the focus of today's topic. In the last 2 or 3 years, we've seen the NLRB focus its scrutiny on employer policies governing employee conduct, and we'll explain why and how they've done that in this presentation. But fair to say, this scrutiny is really unprecedented. Trying to comply with the pronouncements of the board these last 3 or so years has also been difficult for employers. It's been a bit of a moving target at times, requiring some reasoned guesswork in terms of crafting policies that will satisfy the NLRB's shifting position on issues like employee confidentiality restrictions, restrictions on workplace conduct, and the like. The NLRB's Office of the General Counsel recently published guidance on this subject for employers. It's helpful. It provides some clarifications, and today we wanted to share our thoughts with you and summarize this guidance and also support you and your organization's continuing efforts to keep your policies and your handbooks legally compliant and up to date. So let's talk a bit about the history of the NLRA. I think it's helpful to understand where the board is coming from, to understand where it's going today, and why we're seeing this unprecedented pro-union activity on the part of the board. The NLRA itself was enacted as part of FDR's New Deal in Sorry about that, folks. As I mentioned, the NLRA was enacted as part of the FDR's New Deal in 1935. It was certainly a different time for workers then. We didn't have minimum wage laws, overtime laws, child labor laws, etc. Really very little governing activities in the workplace. And the NLRA was crafted to fill this void. Among other things, the Act would come to serve two main purposes. First, to allow employees in the private sector to form or join a union, or not to form or join a union, and also to protect workers and their ability to otherwise band together, even without a union in place, and address work-related issues. In turn, the National Labor Relations Board was created as the agency charged with administering and enforcing the NLRA. After enactment of the Act, not surprisingly, there was a significant rise in union organizing activity across the country, which peaked in the mid-1950s, at which point 1 out of 3 workers were represented by a union. Today we see a vastly different situation. Union membership has continued to decline precipitously, to the point where now 14 out of 15 workers in the private sector are unrepresented. I think there are many reasons for this trend, which are important to consider. Unlike in 1935, we now have a panoply of state and federal laws, as well as local laws in many instances, in place which regulate the workplace and are designed to protect workers. Employers are generally mindful of these obligations and strive for compliance and strive to treat their employees well. And so consequently, one can argue the need for and the utility of unions has been significantly reduced, and the advocacy that once may have been beneficial is no longer as necessary for employees. But rest assured, this has nevertheless been a very distressing trend for unions whose existence depends on the dues paid by union workers and for pro-union officials in our government. So, the NLRB is now consisting of a stridently pro-union majority appointed by President Obama and chaired by Mark Gaston Pierce, who you see before you. And the board has been working hard to change the recent trend and to unabashedly promote a more friendly environment to union organizing. And really this has taken two tracks that we've observed. One, given that almost everyone in the private sector is now working in a non-unionized environment, the NLRB has shifted its focus to those groups of workers and applying the NLRA there. And you see a quote from Mark Gaston Pierce included in this slide, and in his view he says, one of the best kept secrets out there is that the Act does apply to non-unionized workforces in the private sector. Second, I mentioned that employers are generally compliance-minded and generally aware of the laws that are in place and make an effort to avoid those legal pitfalls and steer clear of them. And so what we've seen is the board changing those rules. And I don't think myself as overly cynical, but one could look at this situation and take the point of view that you've got a situation where everyone knows the rules and is striving to follow the rules, but there's a perception on the part of some that those rules are not sufficiently fostering pro-union organizing or union activity, and so there's a need to change those rules. So let's talk about the Act briefly and drill down just for a minute into the provision of the NLRA that is really at the heart of our discussion today. And that's Section 7 of the Act, and you see it before you, what it covers. It guarantees rights to employees to form, join, or assist unions and to engage in other concerted activities for mutual aid or protection. And again, that applies to both unionized and non-unionized workforces. Section A1 makes it an unfair labor practice, or what we'll call a ULP, for employers to interfere with the exercise of those rights. By way of example, Section 7 activity can include a lot of different conduct on the part of a covered employee, including the right to discuss, question, or advocate among or behalf of co-workers with respect to wages, hours, or other terms and conditions of employment. And of course, it also includes the right to engage in union organizing. So one might ask, why is the board focusing on employer policies and handbooks in particular? Well, again, it's striving to stay relevant here, and employers in both unionized and non-unionized settings have employee handbooks. Virtually all employers have some form of policies or procedures in place, and with very good reason, of course. We want to have clear standards governing the workplace and our workforce. And those policies are also generally in writing, which again is done for a very good reason, so that there is dissemination of those expectations and policies. And there can be little question as to what those policies say and what the requirements are. But what this results in is a scenario where these are cases that are very easy, they aren't time-consuming, and they're very efficient for the board to prosecute. And so they get a good bang for their buck here, where they can take a look at an employer's policy, and at the end of the day, there's not going to be a whole lot of dispute over what is said in there, nor sufficient opportunity or much opportunity for there to be a genuine adversarial proceeding over the issue. So it's really a streamlined process that they can use to advance the objectives we talked about just a bit before. So how specifically can a particular policy violate the NLRA? Well, there's multiple ways. First, if the policy outright bans some kind of activity that's protected under Section 7, on its face, that's going to be unlawful. That's not very common in our experience. We tend not to see that. So then it's other circumstances. If you've got a policy that was implemented in response to, let's say, union organizing or other Section 7 activity, that could be deemed unlawful. Or if you have a neutral policy that's being applied in a way that only restricts the exercise of Section 7 rights, that could be unlawful. And finally, if a neutral policy on its face can be reasonably construed to restrict the protected concerted activity of an employee, then that will be found unlawful. And that's really right now where the board is focused on, and why we've highlighted it here is are those neutral policies that the board is now, in my view, bending over backwards in some instances to find are overly broad and can be reasonably construed to infringe the exercise of Section 7 rights. In many instances, these are very common policies that have been in place and accepted for a significant number of years. So with that, I'd like to turn it over to Tyler Hendry, who will start with General Counsel's memo, explain the guidance offered to employers, and show how these rules are being applied by the NLRB.
Thank you, Andy. So I am going to be jumping into the heart of the presentation, which is the General Counsel report itself. Now, for a little background, for those of you not familiar with how the NLRB works, the General Counsel's Office of the NLRB is actually separate from the board itself, and it's responsible for investigating and prosecuting unfair labor practice charges. In other words, after an employee or a union files a complaint against an employer, it is the NLRB's General Counsel that ultimately decides whether that complaint has any merit and whether a complaint should therefore be issued against an employer in that instance. So the General Counsel's office largely plays as a gatekeeper. So here, as you see, it's the General Counsel that issued this report. And therefore, it is not technically legal binding authority because it is not a document or a decision issued by the board itself. However, because the General Counsel holds this gatekeeper role, this report is critical in avoiding having a complaint being issued against you in the first place. And also, it's important to note that the current General Counsel and the pro-union board majorities politics align almost exactly. And therefore, this report is a very strong indication of how the current board would also interpret these policies. Therefore, employers who choose to ignore this report do so at their own risk. So with that cautionary and foreboding warning in place, Andy mentioned over the past few years that the NLRB and the NLRB's General Counsel have been finding many previously common handbook policies that seem to be rather innocuous and common sense restrictions on employee activity to be unlawful on the basis that employees would reasonably construe these policies to restrict Section 7 activity. So, perhaps recognizing that these findings have significantly changed the landscape for employers, the NLRB's General Counsel issued this report. So to sum up what the GC's stated purpose for his report was essentially that everything has changed about employer policies, and it is imperative for employers to keep up. So, as noted, this report itself is useful because it provides a single summary of the General Counsel's views on a wide range of policies. This includes confidentiality policies, conflicts of interest, employee conduct, and a number of other policies that we will get through. As you see here on the slide, Part 1 of the report provides examples of lawful and unlawful policies, and it includes the General Counsel's rationale. And Part 2 essentially does the same thing, but here it does it in the context of explaining a recent action against Wendy's, where the NLRB challenged a variety of provisions in the fast food giant's handbook. Now, before we get into the policies, I want to provide a realistic assessment on what is to be gained from this report. Now, the report is useful and necessary for employers to understand, but it is certainly not perfect by any means. As I stated, the usefulness of the report is in its concrete examples of lawful and unlawful policies that can be used as a general guide in revising your handbooks. Additionally, the report provides some underlying principles behind its findings, and we will highlight those principles as we walk you through some examples. Now, what the GC memo does not do is provide a very clear blueprint for employers to follow in all circumstances. So it is important that you read the rationale and listen to us explain the rationale behind the General Counsel's determinations, because in many cases it is not the language itself that was lawful in the policy, but rather the context surrounding it that rendered it lawful. So this just means that employers must be very careful in simply copying and pasting a lawful example from this report and thinking you're golden. As we will repeat many times throughout this presentation, the context is critical. Another thing that this memo doesn't do is address apparent inconsistencies throughout the report. Now, there are some razor-thin distinctions in this memo between lawful and unlawful policies that are particularly unsatisfying in terms of logic and rationale. But again, this memo is what it is, and what we are here to do today is provide the most critical and useful practical takeaways to gain from this report and not to attack those inconsistencies. So with that, I will now jump into the actual policy examples set forth in the report. So this first group of policies, and a group that we have seen declared overbroad again and again by the NLRB, are confidentiality policies. So just a standard policy attempting to limit an employee's disclosure of your confidential information. Now, the General Counsel's position here in regards to confidentiality policies is essentially anything that directly restricts or an employer would reasonably construe to restrict the ability of an employee to discuss wages, hours, and other terms and conditions of employment will violate Section 7. So what this boils down to is that if you have a confidentiality policy that broadly prohibits an employee from disclosing employee information or personnel information, or it defines the term confidential information to include these things, it will generally be considered unlawfully overbroad, because the NLRB reasons this information would include such things as wages and benefits. Now, as you will see from our examples, you can restrict the disclosure of the employer's confidential information, but confidential information cannot be so broadly defined as to include wages, hours, or other terms and conditions of employment. So all these things that you may not want employees to spread around, like info on salaries, benefits, promotions, and the like, if you restrict their disclosure, you will be in violation of the NLRA. However, you can restrict such things as trade secrets and internal processes and business plans and other similar items. So now we will jump into examples from the report. So here before you we have two unlawful confidentiality rules. The first contains exactly what I just mentioned. Do not discuss customer or employee information outside of work, including phone numbers and addresses. Here, the prohibition on employee information is a very clear violation in the eyes of the NLRB, because employee information could include wages and other terms and conditions of employment. Additionally, here, the restriction on discussing phone numbers and addresses is unlawful, because there is no clarification here on how those phone numbers and addresses may be obtained. For example, an employee could seek to obtain from other employees their names and addresses in support of a union campaign, and this would clearly be within their Section 7 rights. So in this first policy here, we have two unlawful provisions in one very, very short sentence. In the next example, there's an important distinction to be made. The provision reads, never publish or disclose the employer's or another's confidential or other proprietary information. Never publish or report on conversations that are meant to be private or internal to the employer. Now here, what was found unlawful was not the disclosure of the employer's confidential or proprietary information. That first part was fine. Instead, it was the restriction on another's confidential information that was unlawful. So the GC reasoned that this another's confidential information could be interpreted to mean confidential information relating to another employee, which apparently, in the eyes of the GC, could include wages and other information about that employee. So again, the restriction on the employer's confidential information was fine, but the restriction on another's confidential information was not. So moving on to some examples of lawful policies should hopefully clarify this distinction further. So this first example is very similar to the first part of the previous example. It's a restriction on an employer's confidential information. It reads, no unauthorized disclosure of business secrets or other confidential information. Here, the GC found that there's no suggestion that confidential information could be defined to include employee or personnel information, and it was limited only to the employer's confidential information. Similarly, in the second example here, while the term confidential is used, there is nothing around it that would indicate it includes employee information or other terms and conditions of employment. So now we talked about how context is critical. This final lawful confidentiality policy is a prime example of what I was talking about. The provision prohibits the disclosure of all information acquired in the course of one's work. Now here, I think even the most staunch employer advocate might admit that the employer is going a little bit too far here, and that there is no possible way that the NLRB would say that this provision was okay. However, as you clearly see on the slide at the top, this policy was actually found to be lawful. The reason here is because the provision was nested among a number of policies relating to conflicts of interest and compliance with SEC regulations and other state and federal laws. So the NLRB found that in this context, employees would construe the provision to prohibit disclosure of items such as customer credit cards, contracts, and trade secrets, and not any Section 7 protected activity. So again, this is just an example of where you need to be careful to not just pick a provision found lawful in this report and plug it into your handbook. So with that, I am going to hand it back over to Andy to discuss some employee conduct rules.
Great, thanks, Tyler. So just one point here to make. When we're talking about Section 7 rights in employees, when we use that term employees, we mean employees who are covered by the National Labor Relations Act. And not all employees in the workplace are indeed covered. For example, supervisors are not covered under the Act within the definition of employee. And there can be other exceptions too. But what we really mean are rank and file non-supervisory employees in their exercise of Section 7 rights. So with that point, the second main policy area that is under scrutiny frequently at the board and is a major subject of the GC's memo involves employee conduct and professionalism rules. And to boil it down for you as base as possible, what the board has said and what the General Counsel's office is saying is that you can't prohibit employees from criticizing or being rude towards the company or your organization or management. That will unlawfully chill the exercise of their Section 7 rights, which includes the right to be critical of management or their employer. On the other hand, what you can do is require employees to be professional and respectful to other employees, customers, or the public. Now, one point, keep in mind here, the board will, the current board will go to extreme lengths to try and protect employee conduct, and an employee won't necessarily lose protection of the Act even if there's use of vulgar and what I would find to be patently offensive language, as long as there's some connection, even tenuous, to the workplace or work-related issues. There are limits to what type of conduct is protected under the Act. For example, there is authority for the proposition that an employee who disparages their employer's product or service is not afforded protection under the Act. But again, the board is generally loath to apply these limiting principles against an employee's conduct. By way of example, in one recent case, there was a situation where an employee lost his temper, raised his voice, and berated the owner of his company, calling him a blanking mother blanking, a blanking crook, and a blank hole. And the board found that that activity was protected. One other thing to just keep in mind is that the employee conduct and professionalism rules In my experience, they can come into play in a variety of different handbook policies. Of course, you might see them in a code of conduct or discipline provision, but they can also be found in social media policies, technology or email use policies, or harassment policies. Okay, so let's go through a few examples in this area from the General Counsel's memo. I think the analysis here is pretty straightforward, at least according to the board's perspective and where they're drawing the lines here. So before you see two examples, one requiring employees to be respectful of the company and other employees, etc., and the other prohibiting employees from making fun of, denigrating, or defaming their coworkers, customers, and the company. The problem with this policy, according to the General Counsel's office, is that it includes reference to the company in both times in terms of the restriction that was placed, and therefore the policies could be reasonably construed to prohibit the exercise of the employee's Section 7 rights to be critical of their employer or their management. Another example, two examples here. First, a directive that employees have to refrain from, among other things, causing damage to the company's business or reputation, and a prohibition on employees doing something that could affect the employer's business operations or reputation. Here the board found that, again, they could be reasonably read to require employees to refrain from criticizing their employer in public, and that the context of the policies did not contain sufficient examples of other information to make clear that the aim of the prohibition here was unprotected conduct, for example, disparagement of the employer's conduct. So one takeaway here is that the board is indirectly letting you know that, well, yes, there are restrictions, lawful restrictions that you can place in these policies that will be upheld, provided you have appropriate context. Here they lack that context. So let's compare some policy provisions that the board found were lawful. First, there was a prohibition on rudeness or unprofessional behavior towards a customer or anyone else in contact with the company. Second was a provision that each employee was expected to work in a cooperative manner with management and coworkers, customers, etc. For the first provision, the board found it was lawful and indicated that there was no reference to the company or management in terms of the non-rudeness and professional behavior expectation, and therefore that employees would not reasonably construe that prohibition to limit their ability to be critical of their employer or its policies. The second provision, frankly, is a bit hard for me to rectify with the General Counsel's position in other areas, given this, but the lawfulness of this particular provision was premised on the interpretation that all the policy was really doing here was requiring employees to work civilly with one another. And I think the key was this cooperative manner language that was included in the policy. So you've heard us mention a couple times that context is key in terms of the policies, and context can serve to render a provision in a policy that may on its face be unlawful to be lawful under the Act. And I want to give you an example of that here. The first is a policy that limits employees from using email to send anything that's fraudulent, harassing, embarrassing, sexually explicit, profane, etc. The second is a policy that simply prohibits being insubordinate, threatening, intimidating, disrespectful, or assaulting a manager or supervisor. And you certainly can see some similarity between these two provisions. In the first rule, the board found that there was ambiguous language that rendered it unlawful. Otherwise inappropriate, that wasn't clear. Embarrassing, the use of that language wasn't clear to an employee. and even the reference to it intimidating, based on the other ambiguous language in the policy, the use of intimidating or otherwise inappropriate language could lead an employee to reasonably construe the policy as infringing their exercise of Section 7 rights. The second provision, the board said when you look at the policy as a whole and in context of the overall policy, it's clear that this was targeted at serious misconduct, and therefore an employee wouldn't construe a prohibition on insubordination, threats, and intimidation given the context as infringing their Section 7 rights. I think here, again, it's a pretty fine line that's being drawn, and without really knowing the full context of that second lawful policy, it's hard to glean a lot from it. But I think the point here is the board was saying what was being prohibited here was serious misconduct that would not otherwise be covered as protected activity under the NLRA. So just a quick note on false statements. I think this was a useful takeaway from the memo that employers should consider. What the General Counsel has said is that employers cannot prohibit or threaten discipline against employees for making false statements or misleading statements. And the theory here is that such a provision would tend to chill the exercise of an employee's Section 7 rights. Put differently, the employee would be hesitant to voice their views or concerns about a workplace issue for fear that someone later may determine that that statement was false or misleading and impose discipline as a result. But the General Counsel has also taken the position that a maliciously false statement is not protected. All right, well, you're probably saying to yourself, what, or what does that mean exactly? Well, the distinction that the General Counsel draws is that a maliciously false statement is one where the employee knew of the falsity or showed a reckless disregard for the truth. In other words, it was a knowingly false statement. Here, I think the practical takeaway for policy drafters and employers out there is if you have language in your policy that prohibits false statements or could impose discipline for a false statement, simply change that language to include the maliciously false language. Ultimately, it's probably a distinction that won't make a significant difference for discipline purposes, and you'll also comply with the pronouncements of the General Counsel in this case. So with that, I'd like to transfer once again to Tyler, who will talk about some other provisions in the General Counsel's memo.
Thank you, Andy. So keeping up with the theme of useful takeaways here, next are rules restricting the use of company logos, copyrights, and trademarks. Here, the General Counsel's basic position is that an overall ban on the use of the company's logo, copyrights, and trademarks could potentially restrict the use of a logo on picket signs, leaflets, and other protest material. So basically, if an employee wants to make a picket sign with a giant X through your corporate logo or some other defacement of your logo, the NLRB wants to make sure the employee has the right to do so. So a note on the bottom of the page here that we mentioned that this type of rule could become an issue in a union organizing campaign. Andy will explore this more at the end of the presentation, but what we mean by this is that if you were to maintain or attempt to enforce this kind of overly broad rule on restricting what can be used on picketing signs during an organizing campaign, the NLRB could potentially find this to be an unlawful interference with the conditions of the election, and there's a possibility that this sort of interference could invalidate election results. So this means that if you actually won an election, union election, the results could be invalidated in a rerun election. So let's look at a couple examples here. So the examples in this category are fairly straightforward, and this is one area where some concrete practical guidance can be taken from the report. So taking a look at both these policies, they both contain a very broad ban on the use of an employer's logos, copyrights, and trademarks, and it contains no limitation whatsoever. So as you see, why are they unlawful? Very broad restrictions, reasonably read to ban otherwise fair use of the employer's intellectual property. in the course of protected activity. So how do you fix your policy? Here we have a lawful rule on logos, copyrights, and trademark use. And all it says here is to respect all copyright and other intellectual property laws for the employer's protection as well as your own, and to respect all laws governing same. So in this instance, this is one provision where I am actually willing to go out on a limb and say with some degree of confidence that you can copy and paste a provision from the report, and it's perfectly acceptable and advisable. This is a good, lawful policy. There's no context issue at all in this instance, so it makes sense to use it. So if you have an unlawful policy, we suggest revising to comply with what's set forth here on this page. So moving ahead, unfortunately, the next set of policies does not come with that same level of clarity. This set deals with an employer's conflict of interest rules. This is another area where you will find that context can be key. The General Counsel's position is that a broad conflict of interest rule will reasonably be read to prohibit protected section activities such as protesting labor practices, organizing boycotts, and soliciting union support. So the GC takes the position that clearly these sorts of activities conflict with an employer's interests, and therefore restriction on them is unlawful. However, as you will see in our examples, there are ways to make these provisions lawful by providing specific examples of what sort of activities are prohibited and clarifying that the rules are limited to protecting the legitimate business interests of the employer. Again, at the bottom of the page, we note that this sort of rule could become front and center during a union organizing campaign. So this is another policy that should be revised immediately and enforced carefully if a union does arrive at your facility. So now jumping into the examples. So the first is a clear-cut unlawful policy. Employees may not engage in any action that is not in the best interest of the employer. As you see, there are no exceptions here, no clarification that does not apply to Section 7 activities. In contrast, let's take a look at the next example. It provides employees must refrain from any activity or having any financial interest that is inconsistent with the company's best interest, and also must refrain from activities, investments, or associations that compete with the company. So here, the provision restricting activities or associations that are inconsistent with the company's best interests could potentially in isolation be read to restrict union activity. However, in this case, the General Counsel found that the surrounding examples ensure that employees would not read it that way. Significantly here, we want to note that part of the finding that this provision was lawful was based on the fact that it was also included in a section of the handbook titled Business Ethics, that also included requirements to comply with all laws and to provide accurate disclosures to the SEC. So not to sound like a broken record here, but context was also key here in this finding. So this is another provision that may not be lawful if it's simply copy and pasted into a section of your handbook. Now thankfully we move back to some more fairly clear-cut guidance, and this is restrictions on photography and recording in the workplace. The General Counsel's position here is that employees have the right to photograph and take pictures in furtherance of protected concerted activity, and that any broad restrictions on doing so will be found unlawful. So it is important to note for any of you out there in fields such as healthcare or child care, where privacy interests of the clients or the population served is a sensitive one, that employees are given some more leeway in these circumstances to restrict photography and recording, particularly in any area where a client or patient may be present. So walking through a few examples quickly will hopefully provide some clarity on how to properly restrict photography and recording within the bounds of the law. So here are policy examples providing unlawful, overbroad restrictions on photography and recording. The first is a clear example of an overbroad policy with no restrictions at all. In this case, the GC reasoned that employees would be unable to take any pictures to document health and safety violations or to engage in any other form of protected concerted activity. Now, the second example is important to note because it was a prohibition on wearing cell phones, making personal calls, or viewing or sending text while on duty. So generally, an employer may lawfully restrict an employee's viewing or sending text during working time. That's a defined term, working time, which excludes meal periods and breaks. However, the GC found that the use of the term on duty in this case could be reasonably read to include breaks and meal periods during shifts and not just working time. So here, if the employer had simply just used the term working time, they likely would have been in compliance with the law. But it was the specific term on duty that rendered the provision ambiguous and therefore unlawful. The last example here is another example where context controlled. So taking a look at the policy, this is one where you would think the NLRB would certainly reject everything about this policy. No cameras are to be allowed in the store or parking lot without prior approval from the corporate office. So that's an overall broad restriction, got to be unlawful, right? And the twist is that no, this was lawful in this case because it was contained within part of a lawful media policy and it immediately followed instructions on how to deal with reporters coming on to the location. So it would be read as a ban on news cameras and not on personal employee cameras. So some main takeaways here for photography and recording. You can restrict employees from taking photos and recordings during an employee's working time. And if you have a sensitive client or patient base, you may be able to ban all pictures and recordings in patient and client areas. For third-party communications, since we're running a little bit low on time here, I'll just provide a general overview of the main takeaways and not go through the policies in detail. So the next set of policies relates to restrictions on communicating with outside third parties. The General Counsel's position here is that employers' media policies often unlawfully prohibit the Section 7 rights of employees to communicate with outside news media, government agencies, and other third parties about wages, benefits, perhaps alleged mistreatment, and other terms and conditions of employment. This is an area where careful drafting is required, and the critical takeaway is that an employer still has a right to designate certain media contact persons to make official statements on the employer's behalf, but you have to be careful that these rules cannot reasonably be read to prohibit other employees at your facility from communicating to outside third parties regarding other terms and conditions of employment and other matters. So you can designate media spokespersons, but you can't foreclose other individuals at the institution from speaking about other terms and conditions of employment.
And Tyler, just the corollary there, right, is that you can prohibit unauthorized persons from speaking on behalf of the company as a representative, but not about the company.
Exactly. So again, we're going to race through the examples here that you have them there. You can look at the examples, check out the GC's rationale, and
yeah, these examples are pretty clear, I think, and espouse the drill down point that we just mentioned to you.
And for this final set of policies, this is one last example where, again, the GC's rationale here isn't entirely clear, but he does give a very clear takeaway, and this involves policy restrictions on leaving work without permission. The report is just very, very clear that you have to avoid the specific terms walking off the job or engaging in work stoppages because these provisions would reasonably be read to include protracted strikes and walkouts. So this is a matter of look through your handbook. If you've got these provisions in there relating to your restrictions on leaving work, you're going to be in violation of the NLRA. So, but if your rule makes no mention of strikes, walkouts, disruptions, or anything of that sort, employees will reasonably understand it, and the GC's eyes, to pertain to employees leaving their posts for reasons unrelated to protected activity, and it will be found lawful. So with that, that's the summary of the policies. I'm going to turn it back over to Andy to sum up why this all matters and what steps employers can take next.
Okay, thanks, Tyler. So, right, we've covered all this, and the inevitable question is, does this really matter, and if so, what do I need to do? I think it does matter, and it matters for a number of reasons. First, if you have an overly broad and unlawful policy, it could lead to an unfair labor practice proceeding before the board. And again, keep in mind, even as a non-unionized employer, you could face a ULP and have to undertake the cost and time and absorption of other precious resources in defending that case. And again, keep in mind, many of the noteworthy, well-publicized cases of late at the board in this area have involved non-unionized employers. You could be required to make a posting with respect to the violation. Commonly now, the board is requiring not just a physical posting out there in the workplace on, say, your bulletin board, but also an electronic posting using email or your intranet. And of course, the publicity that can go with this. And the board is very excited to publish headlines and promote its findings when it issues complaints or finds an employer has acted unlawfully, and you see the type of headline that could be out there. It's very general. It doesn't talk about the fact that the violation may have been an innocuous policy that really had no effect, and based on a very narrow interpretation of it, rather it would be a broad pronouncement. The maintenance of an unlawful policy, if you're issuing discipline pursuant to that policy, could also provide the basis for an unfair labor practice charge and for the NLRB to invalidate that discipline, in which case reinstatement of the employee could be ordered with back pay, and there could be other relief afforded too. And perhaps most significantly, as Tyler has alluded to, if you have an election and an arguably overly broad policy on the books, it could cost you a victory in a union election campaign. The board has used such policies even when those policies have admittedly not been enforced to invalidate a favorable election for employers. So again, in our view, the stakes can be significant. All right, so what should you do now? Well, we recommend you review and, as necessary, revise your employee handbooks. If you have standalone written policies, as is common, you do the same with those policies as well. Try to avoid broad prohibitions or use of generic terms, right? Personnel information, references to those types of generic terms in confidentiality policies, for example. Eliminate those and other terms that are broad or ambiguous and may be deemed by the board to be reasonably read to restrict the exercise of Section 7 rights. We recommend when you do have policies, include examples and include relevant context that will help dispel the notion that those policies can be read to infringe the exercise of Section 7 rights. And along this line, and I know we got a couple questions that came in on the use of disclaimers, that can be an effective tool. So you can include disclaimers in your handbook, either general disclaimers at the outset or at the closing or both, or in specific policy provisions, making clear that nothing in this policy is intended to infringe the exercise of an employee's Section 7 rights under the National Labor Relations Act. And you can be less specific, you can be more specific, but a couple points here. One, the inclusion of that kind of disclaimer in and of itself isn't going to insulate and protect an otherwise unlawful policy or policy term. But the advantage of it is where there is a close call or there is ambiguity, you can point to that language and say, listen, this policy can't be reasonably construed to infringe the exercise of Section 7 rights. We had a disclaimer right next to it. Again, be careful overly relying on the approved policies. Context can matter, as we've talked about. And also remember that when reviewing your policies, the board can apply a very particular legal meaning to certain terms. Tyler talked about working time. And when we have a regular conversation about working time or an employee working on duty, we may think rationally that that means the same thing. But to the board, it doesn't. Those terms have special legal meanings, and it's important that you avoid using the wrong term that can have adverse consequences for you at the board. And of course, it's important to remain mindful of any other legal obligations you may have under the NLRA. This would include making sure you're not discriminatorily enforcing your policies, let's say, against only union-related activity, and that if you do have a union in place, that you don't violate the duty to bargain by making changes to existing policies. Of course, always apply your policies carefully and consistently. If you're hearing or getting wind of any type of union activity, proceed cautiously. And of course, stay apprised for further legal developments. We can virtually guarantee there is going to be more developments from the board, and it's likely they're not going to make employers' lives easier in terms of compliance. So with that, we'd like to just answer a few questions here right now. I think first and foremost, yes, the slides will be made available afterwards. We will send them links or copies to you so that you have them. Another question we got is this memo binding? Well, no, it's not binding, but as Tyler talked about, it's instructive in something that is important to consider. Given the current board, given its clear agenda to promote more union organizing out there, but ultimately it's not legally binding. Do I need, let's see, we don't have a union. Do I really need to worry about this? Well, yes, as we covered, you do need to worry about this because the board has set its sights on non-unionized employees, and employees in non-unionized settings still have Section 7 rights. Let's see, Tyler, was there any other questions?
We have one question here. How do I protect my company and customers if I can't protect confidential information? And I think what the important distinction to be made here is that you can still protect confidential information of the employer. The important thing is that your definition of confidential information doesn't include employee and personnel information. So any employee information relating to wages, salaries, things like that cannot be restricted. However, you still can protect customer information, trade secrets, know-how, your business processes, some advertising materials internally that you're creating. So you still have the power to restrict confidential information. It's just how you define that confidential information which will determine whether your policy is deemed to be lawful or unlawful.
Another question we received in various forms was maybe more of a comment than a question, was it's seeming incredible the board's position and the length that it's going to protect, which are very vulgar and offensive comments, and that's really incredible. And
that's a direct quote in the question.
I tend to agree, but I think there's some distinctions to keep in mind on that issue. First, what they're really focusing in on in this guidance is those types of comments that are A, directed towards a supervisor or about a supervisor, and B, that concern a work-related issue. And in that situation, the board is saying that that is protected activity. To be distinguished from conduct that can be so egregious, or comments that can be so egregious that they do lose protections of the Act. And so there are boundaries to what can be said and done. And that is, none of this is to suggest that employers cannot prohibit workplace harassment, and you know, we would not advise that. I think it's important that you maintain your anti-harassment policies, but it's good to review those policies also, just to make sure that there isn't language in those policies that could potentially raise an issue under the NLRA as well.
So basically, if an employee came in and called another employee a bleeping bleep hole, and it's completely unrelated to any wages, hours, terms and conditions of employment, or advocating for changes, it's completely unrelated to workplace conditions, but just a dispute between a couple of employees, that is not protected concerted activity under the Act. So again, I guess we can say again for the 9,000th time, context is key in that area as well.
Alrighty, well, we're out of time here and need to wrap things up. Once again, we thank you for your attendance today. We hope this was helpful. If I could, I'd just like to make a very quick plug for Bond's workplace seminars, which will be undertaken around the state in the coming months ahead. For those of you who are not familiar, it's a day-long seminar that we put a lot of time and effort into in trying to provide you as professionals out there with the latest information about developments in the labor and employment arena. There are plenary sessions. We cover a legal update in terms of emerging and new issues under state and federal law, so you're up to speed on that. And there's also a number of breakout sessions and seminars that you can select that fit your particular interests as well. I would just mention that one of our breakout sessions here will additionally focus on employee handbooks. There will be some coverage, of course, of this particular topic and the General Counsel's guidance as part of that breakout seminar, but it will include a number of other areas that are relevant to employee handbooks. So if you have a special interest in that area, I recommend you attend that as well. So thank you everyone once again from Tyler and myself. It was great to be able to present this, and we look forward to working with you in the future. Thanks.